Friday. Happy Friday to our friends around the world. It's been exciting in recent months to run into people or hear from people in the Philippines, across Europe, increasingly in different parts of Africa, South America, Latin America, who've told us they've caught these very informal chats and appreciate both the substance and the style. So for those who are joining for the first time, this is not a webinar with people being called on one by one and making speeches. There's a place for that, of course. This is a chat, and we invite you to be part of the chat. We're watching the comments, and we'll try to respond or even bring you in as we speak. So welcome to our Future of Privacy Forum weekly, almost weekly, except for when things are super busy, privacy chat, where we talk about some of the top issues that are going on around the world. Obviously, this past week and the week before have been dominated by debate and discussion about ChatGPT, the OpenAI technology, the follow-on activities by many other companies, the big tech companies who are rolling it out, but companies around the world who, frankly, some of the world is very shocked and surprised and amazed because it's true for many. This is the first time consumers are directly, talking to a supercomputer and seeing this. But for the more technical and sophisticated among you, I know you have been seeing versions of these technologies. We saw already enforcement in Europe by the Italian Data Protection Authority against Replica.ai. After the company now is cracking down and trying to be more careful because of the enforcement issue, because children who are, interacting or could have been interacting, we see people around the world upset that they lost their boyfriend, their girlfriend, their intimate partner who was their Replica AI chatbot, really engaging with them, and they're very upset. They don't understand why can't they have a sexy chatbot anymore? Why is the company, creating this policy? But, the point is, these technologies, even at a smaller startup like this, have been so profound that people are really feeling upset that they've lost, a relationship. So we can joke about it, and we can remember the movie Her. Did you both see that movie Her? It seemed like crazy, but we are actually at this point. So we try not to get too enamored. One company's doing something different, but clearly, around the world, policymakers, regulators are looking or thinking or trying to understand whether the plans to regulate AI are suitable. I look at it and I'm like, it was not a shock to anyone that these kinds of programs, this was not invented yesterday, that large learning models have this capability. So what kind of regulating were we doing if we weren't, the first time we're actually encountering kind of a very robust example where, like, oh, all bets are off, right? Well, let me get to the topic at hand, though. That's what's top of my mind today, as I've been testing and playing with the different tools to see how they work and understand them. And organizations around the world, companies, government, not-for-profits, employees are testing, are playing with this, are loading sometimes data about their colleagues, their customers. We're very focused on helping organizations who don't want to say no. I mean, they feel they have to be compelled to let employees, students, but what policies need to be in place to make sure that you're not breaking data protection law, that you're not using it in ways that are going to be biased and discriminatory. So that's what's taken a lot of our time this week. But I want to pause and introduce our global privacy lead, Gabriela Zanfir-Fortuna, and Sebastião, Barros, Vale, Seb, as we'll call him, Seb and Gabriela, who are leaders and key players on our global team. They did a report with support from some of the others. Seb had the pen, Gabriela the wisdom and advice, Rob and others on the team with their valuable input. Me only being smart enough to find and hire and give the opportunity to these folks to do their work and to share it with you. So, Gabriela, what was this report? It's not the first time we've taken a look at the strategies of the DPAs. Always insightful to really learn what the authorities are saying their work plan is. Obviously, we now have some experience looking at it a few years over many DPAs. Tell the audience here a little bit more about this report, which we have posted, I believe, already on our page and in the comments, and of course at fpf.org, where you can find all kinds of good stuff.
Oh yeah, all kinds of good stuff. So this is the third year that we're publishing an overview of the strategies and the plans that data protection authorities publicly announced. We're looking at their annual reports. Sometimes they have a section there about what they plan on doing for the next year. Usually the annual reports are looking back, but what we're doing is that we just want to look forward. Have insight into what are the areas that they plan on having inspections, what are the areas where they're planning on having guidelines. And we've been lucky because a lot of them, not many, not all, but a lot of them actually publish these plans, and they are very insightful. And you can pick up on some of the bigger areas that they're interested in, like biometrics. For example, you can identify the sectors of the economy where they'll pay attention to in the coming year and so forth. So the team had a very, very tough task throughout many months to monitor the websites of DPAs and spot whenever they would be communicating something about their future-looking activity. This is how the report came about. There are some challenges. Some of the DPAs publish multi-annual reports. So let's say in 2020, they publish a 5-year plan or something like that. So it's difficult to do this on an annual basis and just be completely accurate and up to date. But we're doing our best. And frankly, Sebastião did an absolutely fabulous job. He has been working on the previous DPA strategies reports as well. Now, in terms of what we found super interesting this year, there's something that we're starting to see with the DPAs, and that's more and more attention to AI. So it's just like you said in the beginning, Jules, everybody is paying more attention to this. And our sense after reading through the strategies and following the activities of the DPAs is that they are realizing more and more that they're very much a regulator for AI today, not waiting to get any additional competencies from the AI Act or from other legislation, because they are seeing that to the extent AI relies a lot on personal data, or to the extent that it spits out personal data, or does something that results in personal data, then they are actually competent to do things. So we're seeing the CNIL that actually created a whole new department this year that's dedicated just to AI. We're seeing the Dutch Data Protection Authority, which also created a department that's looking on algorithms, which of course play an important role in AI systems. So that's one thing that is very interesting and caught my eye. But they are busy bees. I mean, this is just one of the many things that they're looking at.
Seb, give us some of the details. And as soon as we do, I want to come to Alex's question, which is a great one about alignment of EU and US approaches to AI. So I think both from what we see here in the reports, a lot of us are very distracted by the EU AI Act, of course, because it's such a significant development. And I guess we see that that's going to be regulated in a way that is separate, perhaps, than the data protection path. But as an earlier FPF report from the team showed, GDPR is indeed an AI regulatory tool. As Gabriela pointed out, this is on the agenda of the DPAs. Maybe some aspects of it might be beyond, but in large part, certainly when we're talking effect on individuals and personal information, it's hard to escape the fact that data protection has a role. So, Seb, over to you, and then we'll talk a little bit more about AI particularly.
Thanks, Jules. So Gabriela already gave the context of the report. It's noteworthy saying that this exercise, the scan of DPA strategies, comes at a time when GDPR enforcement practices by DPAs has been under criticism by civil society, privacy activists, and even amongst DPAs, some point the finger to each other saying you're not doing enough, and some are even calling for a more centralized role of the DPB in cross-border cases, for instance. And you can also see that trend also in other EU data strategy legislative files, such as the DMA and the DSA, in which the regulatory competence fall on the European Commission, also because from the reports we have seen, there are perceived enforcement failures by the part of DPAs under the GDPR, and so the EU legislator is keen on wanting to avoid a similar situation going forward. There's also the fact that DPAs have consistently reported a lack of enough financial and human resources that basically prevents them from fulfilling their role and tasks under the GDPR in many instances. So DPAs do need to be smart about how they prioritize their tasks, their investigations, and also their guidance issuing efforts. So we could understand from this report, we analyzed strategies from 9 European DPAs plus the DPB and the DPS, that DPAs are focusing on issuing guidelines, specifically the DPB, on very impactful topics under the GDPR. This includes what constitutes legitimate interests, which has also been under discussion from the practice of the Dutch DPA in specific cases, the application of data protection rules to scientific research, protection of children through the GDPR, anonymization and pseudonymization, which we all now know that's going to be 2 different separate guidelines that are coming up. And also, and going back to your points on AI, how the AI Act and the GDPR will interact and will be applied by both AI providers and users. We'll also have guidance on that. But not only at the DPB level, but also DPAs are going to issue their own guidance. We see the DPC issuing guidance on children's data, the CNIL focusing more on AI and biometrics with several different projects on smart cameras and analytics technologies. And also the Belgian DPA focusing more on direct marketing and cookies. We've seen several decisions also in recent months from the Belgian DPA. Besides, and before jumping into the enforcement trends and what are the plans of DPAs there, DPAs also focus a lot on raising public awareness, not only amongst data subjects about their own rights under the data protection framework, how they can exercise it, what they consist of, but also on providing information and training for data protection officers and privacy professionals. So we see the Irish DPC, the ICO in the UK, all developing resources for DPOs and privacy professionals to be able to better assist controllers and processors in complying with the rules, which will also be more important now because the new coordinated enforcement framework that the EDPB launched just a couple of days ago will focus on the role and the position and independence of DPOs inside organizations. So there will be investigations across Europe on that specifically, which also has a neat link to what the enforcement areas that DPAs will be prioritizing. Gabriela already mentioned AI and biometrics, but indeed the French DPA, the CNIL, has mentioned a particular focus on investigating international data flows in the context of cloud services, but also now in the context of mobile apps. And it is clear that they will use the powers under the e-privacy directive rules, so the national rules transposing the e-privacy directive, possibly to go around the one-stop shop mechanism of the GDPR and enforce some of the consent rules under the e-privacy directive in specific cases, like they have done in the past. Something that is also noteworthy is that DPAs plan to, in general, prioritize complaint handling, but others, like the Danish Data Protection Authority, are planning to handle more strategic, high-impact cases impacting a lot of data subjects or in more sensitive sectors of the economy like health, than giving priority to handling thousands of complaints that they receive every year. So you can see that they will focus their efforts more on cases involving a lot of people, which is also in line with some of the criteria that the EDPB has approved for the selection of strategic cross-border cases that are handled in cooperation between different DPAs. And cooperation indeed, not only between DPAs, but regulators are planning to bolster their talks and coordinated enforcement efforts with other sectoral regulators, such as consumer protection authorities, consumer authorities, banking authorities. We see that in the UK, but also in France and in the Netherlands, where there are informal coordination networks of different regulators that will start talking more often about how to enforce the rules that involve the processing of personal data across their sectors and responsibilities.
Team, do we think there were some surprises here? I mean, obviously some of these issues, we already see them in the news. They're subject to a lot of debate. But sometimes when you take a look, you realize that, maybe what's making the headline, because that's what the media pay attention to or so forth, isn't really where the authorities are spending a lot of their time and activity. It just may not be the most attention getting. Anything unusual or surprising? Any outliers? Any sort of DPAs who have some strategy that seems very different than the others? What's the overall reaction when you look at this as a whole?
Well, maybe I can go ahead. Well, there's nothing which is very surprising. The DPB has published the work program for 2023 and 2024, which draws significantly on the last work program that they had. They added some new guidelines and areas of focus there, like this interplay between the AI Act and the GDPR, which is on the news, but also something that has not been so much the focus of privacy professionals, maybe, that is strategies for GDPR compliant tools for combating the spread of child sexual abuse material online. This is also being debated at the EU legislative level with a new proposal, and it's been heavily criticized by civil society and DPAs for disproportionately impacting the rights of users of telecommunication services, but also voice over IP services like WhatsApp, because they're basically arguing that it would create a backdoor to encryption services. So this is something that the DPB will try to, before this new legislative proposal passes, clarify how controllers and processors could carry out this monitoring and takedown of child sexual abuse material online. So this was one of the maybe surprises that we've seen. The rest, I think, it's very much what we would expect, also given the conversations that DPAs have been having since the EDPS conference last year on the effectiveness of GDPR enforcement, closer cooperation. Also, the Commission will publish a new proposal on harmonizing procedural rules that apply to DPAs on the enforcement of GDPR cases, notably aligning national laws on the timelines that they have to handle complaints, or that they have to consult with other DPAs in the context of the consistency mechanisms under the GDPR. So you will also see DPAs contributing significantly to the thinking behind that proposal, and hopefully you will address some of the long waits that data subjects need to go through before seeing their matters handled by data protection authorities. But I would say these are the two things that we're looking forward to the most and were the least expected.
friends that are listening, please drop any questions in the chat and we'll try to turn to them in just a bit. I think we also might note that there's an expression in many languages, about how the best laid plans can go astray. There's a interesting Yiddish one that goes something like this: man plans and God laughs, right? And so obviously for a lot of DPAs, complaints are what drive activity. I know I was talking to one DPA and I said, listen, I know the cookie issues are important, and for some DPAs, this is an area that they've made a priority, but hey, you have these very significant issues across all society, and hey, you're fully consumed with, chasing which analytics tool and so on and so forth. And they said, look, this is where we have complaints, high profile complaints coming in, and it can take a lot of time to, work on these. And so, this was our work plan, but this is what ended up, consuming a bigger part of our time, because this is where, complaints are driven. So look, this can be appropriate too. Complaints are an indication of what the world cares about, but maybe we don't always see, work plans resulting the same way, the planning, oriented. Let's turn a little bit to the AI question, and then I see also Joanna flags to us, is data protection of employees an important area for any DPAs? Actually, let me jump into that. Was that flagged in any of the reports?
Go ahead.
Yes, indeed it has. At least in the ICO plan, there's a specific focus on automated scoring for job applications. So we can see that it's also been a focus of DPAs in enforcement cases and in guidance, the use of automated tools in a bunch of contexts, not only for job search, but also credit worthiness assessments to get loans. We saw yesterday a very inspirational opinion from the Advocate General of the Court of Justice in the EU in a case related to Article 22 of the GDPR, in the SCUFA case, that basically has a very broad reading of the prohibition under Article 22 that not only would encompass final decisions impacting data subjects. So, for instance, the decision of whether to give a loan or not, but also profiling decisions that basically narrow the chances of data subjects receiving loans down the road. That's what happened. So the same could be applied in different contexts, such as in the employment context. So if employers are using automated tools to assess the performance of their employees, or automatically assess job applications with regards to the style of writing, with regards to the hours spent in a specific task, etc. And in 2 or 3 years, then they would use that type of information to decide on whether the employee gets a promotion or not, gets a benefit or not. Then it's possible that that would still qualify under Article 22, even if the decision is not fully automated, even if there's still a human in the loop. If the human actually takes the algorithmic recommendation as the sole source of information, or as the decisive factor in the decision-making scheme. So we can see that it is applying in more cases than possibly initially we would have thought of.
Let's turn to the AI questions, of which we now have two, both in the same direction. So I guess we have some good idea of what the EU approach is because of a mature, legislative process, and obviously it's not done yet, but we see the parameters, we see conformity assessments, we see designating high risk. Clearly the EU is far down the line here. Let's not forget that Singapore and other jurisdictions are also very much, at the table with different approaches. Singapore just launched almost sort of a tool that many of us are looking at closely. So let's assume we kind of know the EU approach, although again, Gabriela cautions us, it's not just the act. Data protection law hasn't yet fully given us all of the case law that we're going to see. And it could even be that while we deal with the finalization of the AI Act and all the steps that need to happen to put that in place, the DPAs are not walking away, and we'll see more case law, hopefully in a compatible way, but we'll see more and more application. And so the last word on regulation in the EU has obviously not been said. What does the US side look like is a more complicated story, of course. One thing I should flag is that the California Privacy Agency has authority to do rulemaking under the CPRA around automated decisioning. They currently have a process open at the moment. They've held roundtables and so forth. And we saw in many other areas where the statute maybe was quite lean, we see the agency really looking at EU law, at global law, and building out much more deep regulation in areas where people said, well, they said something about minimization, but it was really just a small mention. And the agency is certainly looking to use that authority quite broadly, and has in many cases the authority to do so. I suspect we'll see, litigation. The global privacy control was not a very big part, and became a very big part. So don't forget, California is going to regulate, and clearly you see the influences of very specific GDPR language. Which state was it? Kentucky. Kentucky just passed. Keir Lamont, our U.S. privacy lead, and Gabriela were just chatting about the state of Kentucky, which we know famously for bourbon and horse racing, but not usually the first place that you think of as like a leading tech regulator. And this just passed one of their two houses, so maybe it won't succeed. However, they passed a proposal that really tracks, for the first time, needing a legal basis to collect and process data. At the end of the day, I argue the differences in US law and EU law are not radically different when you start digging into reasonable and fair. We have different terminology, but at the end of the day, the biggest difference, however, is that unless we're talking about sensitive data, typically collection, as long as you have notice and you're not deceptive or unfair, which again can get pretty far to issues like legitimate interest and so on and so forth, but you don't need to state a particular legal basis, and debating which is the legal basis isn't the front door to legislation. This Kentucky proposal, which passed one of their two houses, actually requires legal basis. Okay, so what are we going to see in the US? We obviously don't have very significant federal proposals around AI yet. We do have privacy proposals that do have very significant language, just like we talked about automated processing, the ADPA, the other major proposals, nothing like the detail and the specifics that are laid out in the AI Act, but do have a few sentences that could be fleshed out by rule and rulemaking around things like automated decisioning. The California one requires explaining logic and so forth. So maybe that's a quick response to that. Our EDPS points out that in Europe, in our comments, labor is an area that is less harmonized by the GDPR because of the traditional respect that this is a national domestic priority. And so don't miss out on the fact, Wojciech reminds us, that there are extensive protections that may not be thought of as data protections, but are labor law protections. And frankly, this is an area where I'll flag also in the US, since we often pay so much attention to the consumer protection law and the employment area, which is also deeply regulated by federal and state agencies, the credit area, the banking area, those regulators have long been regulating, and certainly they see uses of data and the rights and freedoms that affect individuals, whether it's in the workplace or in finance. We may not. I will tell you that the Biden administration perhaps has a sensible area, because this is where they have control, and the congressional situation is more complicated with the very divided House, has made a priority of ordering all of the agencies, HUD, our housing agency, the civil rights agencies, the employment agencies, to look at AI and to use tools to combat discrimination that is digital driven as a major focus. And you saw this in the State of the Union. You've seen this in some of the orders. And so these wheels move slowly, and they're not as busy and noisy as legislative. But these agencies have had these tools based on their law for quite some time. So don't miss out on that. And good point from our European Data Protection Supervisor to remember that although data protection is the law of everything, it seems nowadays, there's many regulators with deep authority, criminal authority sometimes, and we ignore them at our peril, only because they're not new and they're not novel. What do you guys think? Jump in on the on any of the issues. Here's a good one. Maybe we have also a point. Do we see a pattern or trend where the small or medium authorities follow the priorities of the bigger ones, or do they really focus on the very specific issues in their jurisdiction? Should the authorities do some coordinated work? Of course, now there is an effort at the DPB, Gwenda Legrand, other senior folks who've joined that effort to actually create a bit more of a coordinated agenda. Obviously, we see legislative proposals in Europe to begin, well, I guess not yet legislative proposals, but we see the discussion to open the door to relooking at the complicated structures of the one-stop shop. Gabriela, Seb, jump in.
There's so many points here, but I would say going back to the commonality between the EU, or common ground between the EU and the US in terms of their approach to AI. Just two thoughts. One of them is that if we're looking at how DPAs and privacy regulators are relying on existing law to do something about algorithms, automated decision making, and so forth, there are some commonalities. There is some common ground. And I know that a lot of the European DPAs are looking at the FTC and their practice to order deletion of algorithms, right, as an innovative way of doing things in enforcement. So there is that type of, let's say, bridge between the continents. In terms of AI policy per se, if we're looking at what the White House published in the blueprint for AI, the principle-based proposition that the White House is making there has similarities to how the European Union is looking at these issues as well. And it has similarities with the general idea of data protection and how people have rights with regard to how their data is being produced and used in society. So there is a bridge there, but frankly, the level of conversation is much more targeted in Europe. The discussions about legislation, we know for sure will lead to legislation with the EU AI Act. So there's a bridge, but there's also a gap. And hopefully we'll see the US a bit more serious about this effort.
Alex says, fair to say that as California goes, so does the nation. The answer is no. After some initial laws that really were modeled closer on California, Colorado, Virginia, which had more flexibility, but were very similar, we're seeing a road downhill now. Iowa just passed a very weak law. Utah passed a weak law. So to our friends who excited about the states doing their own thing, being the laboratories of democracy. We don't need a federal law. We should have state laws that are going to maybe go further, don't preempt them. Well, we're going to end up with I don't like saying patchwork. I was a state legislator. These are big, New York, California, Texas, Florida. These are very large, jurisdictions with economies bigger than many countries. As a state legislator, we were entitled to set the rules for our own, citizens. However, the country is very diverse and divided, and we will get some very weak laws, and then some stronger ones. Is that really the right, end goal that we have? Whether you're protected for really essential rights and freedoms. If it was just marketing, okay, whatever. So in one state, you're going to get more direct messages and get more cookies. We're talking about AI. We're talking about discrimination. We're talking about really critical areas where we want a consensus for the kind of protections that are in place. All right, we've gone over time. It's in the middle of people's workday. It's later in the day. Final thoughts. What can we share, or what can we add with regard to the reports? I urge the audience to take a look as well at the report that Mercy on our Africa team did, looking really maybe one of the first reports like this at the priorities of the African data protection authorities. Last words, Gabriela, Seb?
Two things to pay attention to there, not in the report, but very important in the DPA world in Europe. First, we will have a new chair of the European Data Protection Board sometimes this year, because the mandate of Andrea Elinek is ending. So let's see what that brings in terms of impetus in change with the EDPB. And then second, there is, of course, the one-stop shop war still brewing in Europe, and we'll have some cases at the Court of Justice of the EU that will look directly to that in the Irish DPC versus the EDPB cases.
Well, my final thoughts would be, don't look only at the DPA enforcement, because the class actions directive is coming into full force this year, with the deadline for member states to transpose it into their national laws. And we already can see some class actions that allege GDPR breaches and claim compensation on behalf of thousands or millions of data subjects surfacing in the Netherlands and beyond, and which can have huge implications and bigger, actually, financial implications for businesses than some of the GDPR breaches that we have seen. So if the Court of Justice does not interpret the concept of non-material damages very restrictively, we can see indeed that some class actions can cause real pain for businesses that breach the GDPR.
Thank you, Sebastião. Thank you, Gabriela. And thanks to those who tuned in. The report is on our site. Please download and take a close read. And we look forward to speaking with you next week. Bye all. Thanks, FPF team in the background who helped make it happen.
Thank you.